We're back to give you the legal edge. There's still a lot of confusion surrounding the state Supreme Court ruling on Friday that struck down months worth of orders by Governor Gretchen Whitmer aimed at preventing the spread of COVID-19. I spoke with attorney Bryan Waldman from the Sinus Stramus law firm to find out why the justices ruled she exceeded her power and to get some clarity about what this means for schools and others moving forward.
Javon, you had 4 justices of the Supreme Court who said that the governor didn't violate the act, but that the act itself, the Emergency Powers of the Governor Act, is unconstitutional because it didn't give the governor enough guidance. It just said that the governor, when he or she issues these orders, has to do what's reasonable and necessary, and that's too broad, too indefinite, not enough. And then you had the 3 justices who dissented sign an opinion that said, well, wait a minute, we think it did give enough clarity here. For the governor to make a decision regarding an emergency, it has to be reasonable and necessary. It has to be to protect life and property and bring the emergency situation under control, and that there has to be a reasonable apprehension of immediate danger when public safety is imperiled. And they said that's plenty of guidance for the governor, so we wouldn't strike this law down as being unconstitutional. But again, it was a split, very close decision, 4-3 among party lines. But remember, we still have the Emergency Management Act, which allows the governor to declare emergencies. The difference is the Emergency Management Act requires after 28 days an extension of the emergency by both the legislature and the governor.
What does this mean for schools moving forward?
That's a big concern for a lot of people. But when it comes to schools, remember, even if the governor's orders don't apply, we actually had bipartisan legislation that was adopted, the Return to Learn legislation, and that still applies and is in effect.
What new developments have come down since the Supreme Court?
So the director of the Department of Health and Human Services has issued his own orders that step in and fill what he perceives to be the void if the governor's orders are no longer valid. And that's based on a Michigan statute that says that the director of the Department of Health and Human Services, if there's an epidemic and the director determines that the control of the epidemic is necessary for the health and well-being of society, that he can then, or she can, in this case he, implement certain emergency orders. And so he's gone ahead and implemented a number of orders.
Thank you, Bryan. And we have a breakdown of the Health and Human Services emergency orders on our website, WLNS.com, and on our 6 News app, which is free to download.